Newsroom. My name is Neil Marks. We're live outside the Court of Appeal, where 3 judges have just completed hearing arguments in the case brought before them, seeking to force the Guyana Elections Commission, GECOM, to pronounce on the credibility of the elections before allowing the Chief Elections Officer, Mr. Lowenfield, in presenting a report of the results of the recount, which would eventually lead to a declaration of the PPP as a winner of the elections and the swearing in of Irfan Ali as president. Now, attorneys for the opposition leader, attorneys for Mr. Irfan Ali, the chair of GECOM, and representatives of 5 political parties which contested the elections presented the arguments before the Court of Appeal today. The 3 judges on the bench are Justice Don Gregory Barnes, Rishi Persaud, and Brassington Reynolds. Now, the attorneys for the opposition leader, for the GECOM chair, for the 5 parties represented, which contested the elections, and others argued that the Court of Appeal only has exclusive jurisdiction to determine questions regarding the election of a president, and particularly regarding the qualifications of a president and his election. They argue that since the election process has not yet been completed, this case cannot come to the court because there has been no election of a president. President David Granger remains in office. Dr. Irfan Ali has not yet been sworn in as president, and so because that election has not yet happened, they argued that this case could not come to this Court of Appeal. The arguments were that the High Court, in an elections court, is the rightful authority for any questions regarding the credibility of an elections, and that the Guyana Elections Commission nor the Court of Appeal has that sort of jurisdiction. Now, exactly 1 week ago, the Chief Elections Officer, Mr. Lowenfield, submitted his initial report on the national vote recount, which was held at the Artichon Conference Center. Now, in submitting that report, he presented the correct results of the recount, which showed the PPP winning the elections by 15,416 votes. But Lowenfield, in presenting his report, laid down several unsubstantiated allegations which were made by the incumbent APNU plus AFC regarding the elections process. According to the coalition, there were a number of anomalies, irregularities that showed up in the elections during the national vote recount, and so they had been calling for an annulment of the elections, for the Chief Elections Officer not to be able to declare these results. That is a contention that the Attorney General made in his arguments to the court today. It was interesting because the applicant who has brought this case, Esyln David, her attorneys never made any such claim. All they're asking the Court of Appeal to do is to interpret what it means in a particular article of the Constitution, Article 177.4, in fact, which speaks to a president being elected once more votes are cast for that particular candidate in an election. Once 1 or more parties contest the elections, basically the one who has the greater amount of votes, that's the one that would win the elections, and the candidate leading that list would be elected president. Now, as I mentioned, Mr. Lowenfield presented the correct results of the recount, which showed the PPP winning. But in addition to presenting the tabulated votes, what he also did was to submit a report. Now, according to the recount order, Mr. Lowenfield was expected to present a summary of the observations that were made during the national vote recount. But what he did is that he took all of the observations, he analyzed them, and then he came up with some figures. And very curious what he did, because in presenting this document in which he analyzed the anomalies, the irregularities that showed up in the recount, what he did was to say, listen, there were this amount of ballot boxes that had problems, and so I'm going to calculate the votes from the boxes which had absolutely no problems at all. So he did that, and he subtracted all of the votes from the boxes he said were in question. Now, that is very curious, because when he did that subtraction, the total amount of votes he counted was 185,260. Now, in doing so, what he did was to discard 275,035 votes because the national vote recount showed that there was a total amount of votes, or the total amount of votes cast was 460,295. So if he's saying that it is just 185,260 votes which have no question about them, then he's discounting over 275,000 votes. That's an incredible claim indeed. Now, of the amount of the votes, Lowenfield says there is no question. He determined that 125,010 votes would go to APNU plus AFC, making them the winner of the elections. For the PPP, he calculated just 56,628 votes. But the actual votes in the recount showed the PPP winning the elections with 233,336 votes, and APNU securing second place with 217,920 votes. Now, the applicant in the case, Esyln David, has sought a declaration that GECOM has failed to act in accordance with its own order. Now, the recount order, when it was published, showed that the intention, or one of the objections of the recount, was to establish the credibility of the vote count. And so she is claiming that because GECOM did not do that and then asked Mr. Lowenfield to go ahead and submit a report, then they were in breach of their own order. So she wants a ruling from the court to say that the chief elections officer should not present any report until GECOM pronounces on the credibility of the elections. But parties in the case argue that according to Article 177(4) of the Constitution, the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, insofar as the question depends on the qualification of any person for election to that office. Mr. Ralph Ramkaran, one of the attorneys arguing for a new and united Guyana, the Liberty and Justice Party, and the new movement, he argued particularly on that question of qualification, that yes, you can come to this Court of Appeal, but you can only come to this Court of Appeal when it is regard to questions about the qualifications of a president. And in his written submission, he spelled out the clear legal definition of what that qualification is, meaning any person who's running from office has to be a resident of Guyana, has to be living here, and those sorts of qualifications. And so it addresses nothing of the claims that were made by Esyln David in her application to the court. Now, the applicant's case was supported by the Attorney General Basil Williams, but there was a bit of gap because the attorney for Ms. David parted ways with the Attorney General, saying that he is not seeking an annulment of the elections as the Attorney General is. The chair of the Guyana Elections Commission, in her written submissions, has made all of those arguments that this Court of Appeal cannot hear any questions regarding the credibility of the elections, that it must go to an elections petition in the High Court, and so she has called for this Court of Appeal to throw out this case. She said that the application is misconceived and ought to be struck out forthwith, and that the Elections Commission should be allowed to perform its functions. It should be allowed to see this elections process to an end, and that end of the elections process will only come when there is a declaration of the winner of this elections and the swearing in of a new president, again, which the recount has showed is Dr. Irfan Ali of the PPP. And so the Court of Appeal will rule in the case at 1:30 on Monday. And of course, we'll bring you that ruling at that time. For now, I'm Neil Marks outside the Court of Appeal.